policing the police every single day, and doing what the Charlotte County Sun newspaper and local TV stations won't do every single day.
Hey, Charlotte County, this is Charlotte County COPWATCH, and we got to do a story on this. And I will do this. I will attach the screen read to this of this court order, but this is going to be insane because I do admit I hate Ian Mcguire's guts. He tried to kill me and my family 3 times. It's all documented, recorded, 911 calls, video of them sending the cops over to kill us, all that good shit. But here's a good thing that came out of this, and I admit I was 50-50. I was half, get them on a gun charge, and I was half like, it doesn't say anywhere in the Second Amendment they can take your fucking guns for anything. And taking your guns is stupid because you can get a gun anywhere. It is stupid. So this is why I'm making the video. This case law for Florida, we think the nation too, literally has given your gun rights back if you have committed no violence. So let's say you have a domestic order against you or a stalking. If there is no actual violence in there, you can get your guns back, take it to court. Also, red flag laws. If there is no violence anywhere in that red flag law that you get hit with, take it to court. You can get your guns back. Like I said, even Eric Friday, the best gun lawyer in Florida, said, holy shit, when he saw this. And so did Florida Carry, the biggest gun rights group in Florida. So this is huge. Highly recommend. You can get this from the Charlotte County Court website yourself. You can, like I said, you'll see the screen read. You can find this. This is epic. It basically said, and it's true, you have to follow what the federal says. Federal says there's got to be violence. And this is how out of control our goddamn fucking felony sheriff, Charlotte County Sheriff Bill Promell is, who is a felon, by the way. He had a legal list of gun owners, illegally profiled them, and he's doing misdemeanor offense every fucking day, violating our rights to records law. He even took away Ian's guns for DUI. Where the fuck is violence in that? So here's another thing. You can possibly sue the fucking shit out of your police, your state attorneys, this piece of shit Bill Promell himself, and on and on. Your Second Amendment has been violated. And this is a judge that wrote this, and a highly respected judge that teaches judges in Florida. So this is a big deal. This is a good part. Ian Mcguire just got your gun rights back if you have no violence. You got to look at the whole document. It's near the end, and halfway through, whatever, and or watch the video of the screen read. I go right. So this is huge. Ian Mcguire got your gun rights back. Remember what the founding fathers said? Take your goddamn country back. You're a frog in a pot. The water's gone. You're on the bottom frying. Get the hell out and fight.
In the County Court of the 20th Judicial Circuit in N4, Charlotte County, Florida Criminal Division, State of Florida, Plaintiff, V.S. Ian Mcguire, Defendant, Order, Case No. 19-1001M. This cause having come before this honorable court at the close of a non-jury trial. Upon the defendant's motion for judgment of acquittal or to dismiss, the court having considered the evidence and citations to authority and heard argument of counsel and being fully and otherwise advised in the premises does hereby find as follows. 1. The defendant is charged in the state's information in Count I, pursuant to Florida Statute 790.233 with possession of firearm while under stalking injunction, and in Count 2. Pursuant to Florida Statute 784.0487, 4a, 7, with violation of injunction for protection against stalking. 2. The material facts of the case are not in serious dispute. On February 22, 2019, the defendant was served at 3365 West Lund Terrace, Port Charlotte, Florida with an order setting hearing on March 5, 2019, on a petition for injunction for protection against stalking. On March 5, 2019, at the conclusion of the proceedings, the defendant signed an acknowledgement that he had received a certified copy of the final judgment which was entered that day by Judge Mary Evans. A copy of that final judgment is attached to this order as Exhibit A. 3 On June 27, 2019, Charlotte County Sheriff's Deputy William Prummel, I.11, executed a search warrant at defendant's home, 3365 West Lund Terrace, Port Charlotte, Florida, and found, among other things, numerous firearms and pieces of ammunition inside defendant's home under defendant's exclusive care and custody. 4 At trial, the defense, during their motion for judgment of acquittal or to dismiss, argued 2 points. The first was that since Florida Statute 790.237 reflects in paragraph 3 a desire by the legislature to have its law conform to the federal law, and since the federal law requires a domestic element to the parties' relationship for its companion law to be enforceable, Florida's law cannot be enforced because it lacks that domestic element. The motion was denied on that ground. 5 The second ground was that the law is unconstitutional because it violates the defendant's right to keep and bear arms as acknowledged in the Second Amendment to the United States Constitution. This court initially reserved ruling on the second argument, and it is the purpose of this order to address that second point. 6 The defendant cited to McDonald v. City of Chicago, IL. 561 U.S. 742, 130 SCT. 3020, 177 L.ed 2D 894, 2010, for the proposition that an individual's right to keep and bear arms, as acknowledged in the Second Amendment to the United States Constitution, is applicable to the states through the 14th Amendment of the United States Constitution. McDonald, Supra, cites to District of Columbia v. Heller, 554 U.S. 570, 128 SCT 2783, 171 L.ed 2D 637, 2008, as the beginning of the most recent discussion of the breadth of the right acknowledged in the Second Amendment. 7 In Heller, Supra, while the court failed to establish any level of scrutiny for the various activities involved in keeping and bearing arms, it went on to say, you enter any of the standards of scrutiny that we have applied to enumerated constitutional rights, banning from the home the most preferred firearm in the nation to keep and use for protection of one's home and family would fail constitutional muster. It would appear that the two Florida statutes in question do this very thing. The unique facts of this case find the defendant charged with a crime because he kept firearms in his home, while, in a different case, the statute might also make illegal conduct associated with keeping and bearing arms outside a person's home that is not the issue in the instant case. So, the next question is there anything in Heller, Supra, that might rescue the statutory limitations on the keeping and bearing of arms from being unconstitutional? 8 The Heller, Supra, court did acknowledge that the right to keep firearms does not protect him who uses them for annoyance or destruction. Citing to Commonwealth v. Blanding, 20 Massachusetts 304, 313 to 314, and also quoted the statement, the Second Amendment right ought not be abused to the disturbance of the peace, such as by assembling with other armed individuals for an unlawful purpose. The opinion also stated, the right secured by the Second Amendment is not unlimited. Nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. 9 Florida statute prohibiting possession of a firearm by a convicted felon has been Upheld by Florida Supreme Court, Nelson v. State, 195 So.2d 853, FLA 1967. This ruling has not been reviewed by the Supreme Court. 10. The somewhat analogous federal statute precluding possession of a firearm by certain convicted felons has been upheld by the federal courts of appeal. Cases v. United States. 131 F. 2. 2D 916, CCAI 1942, and the U.S. Supreme Court denied CERT, cases v. Lasquez, v. United States, 319 U.S. 770, 63 S.CT 1431, 1943. 11. There is a noticeable difference between the federal statute prohibiting possession of a firearm by a convicted felon and the analogous Florida statute, that being that the federal limitation contained in the statute approved by the cases, Court is on those convicted of violent felonies. 12. As pointed out by the defense in the instant case, there is a difference between the Florida law limiting gun possession by a person under an injunction and the federal law covering the same subject, and that is the requirement in the federal law that the parties have some type of intimate relationship, which suggests Congress believes that domestic type relationships are inherently more dangerous than other types of relationships. 13. Which brings us to the ultimate question in the instant defendant's case. Is a finding in a civil court that a person should be enjoined from contact with another person, standing alone, sufficient to limit the natural right of a person to keep and bear arms inside one's home? 14. Florida Stalking Injunction Statute, Florida Statute 784.0485, follows immediately on the heels of Florida Statute 784.048, which defines various stalking criminal charges. The most basic of those charges, stalking, Florida Statute 784.048, 2, is described as follows. A person who willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person commits the offense of stalking. Harass is defined by statute as follows. To engage in a course of conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose, Florida Statute 784.048, 1, a. Course of conduct is defined as follows. A pattern of conduct composes of a series of acts over a period of time, however short, which evidences a continuity of purpose. Florida Statute 784, 1, b. 15. It would appear that any constitutional challenge under the Second Amendment to the U.S. Constitution to the criminal prosecution under Florida Statute 790.233 and Florida Statute 784.0487, 4, a. 7 would require strict scrutiny, at least as it relates to conduct inside one's own home, as the criminal statutes are directed at conduct and that conduct is the very conduct protected by the Second Amendment. See generally Heller, Supra, and Burroughs v. Corey, 12 Sup. 3D 1201, MDFLA 015, at the least, and as applied challenge would require strict scrutiny. Burroughs, Supra. To survive strict scrutiny, the government has the burden of 3. Showing that the statutes in question are necessary to serve a compelling state interest. Burroughs, Supra, First National Bank of Boston v. Bellotti, 435 U.S. 765, 98 S.CT 1407, 55 L. ed. 707. 16. Given the posture of the law applicable to this case, the state would have to show that the injunction statute, Florida Statute 784.048, was designed to reduce or eliminate some conduct associated with gun possession, for example, physical violence. This would be necessary in order for the criminal statutes, Florida Statute 790.233 and Florida Statute 784.0487, 4, a. 7, to be characterized as necessary to serve a compelling state interest, to wit, reducing physical violence. 17. The injunction statute, by its language, is designed to reduce following, harassing, or cyberstalking. Reducing harassing is designed to reduce, among other things, substantial emotional distress. In order for reducing following, harassing, cyberstalking and substantial emotional distress to be necessary to serve a compelling state interest sufficient to regulate gun possession, the courts would need to be construing those phrases in the statutes in question to mean following for the purpose of potentially engaging in violence, harassing for the purpose of threatening or engaging in violence, cyberstalking for the purpose of threatening or engaging in violence and causing emotional distress by threatening or attempting violence. 18. Florida courts have limited the statute's application by taking a narrow reading of substantial emotion distress. Burroughs, Supra, discussing a challenge to Florida Statute 784.048. However, in TBV State 990 So.2d 651, FLA 46 DCA 2008, the court held that using homophobic slurs on three occasions would likely cause substantial emotional distress. The only comment associating the defendant's conduct with potential violence is when the appellate court said that the victim, not the defendant, may respond with violence. In Grusin v. Walker, 714 So.2d 1149, FLA 2 DCA 1998, the court upheld an injunction based on four videotapings. The defendant's conduct was unassociated with any expressed concerns of violence, and the opinion of the court addressed by analogy another limitation of conduct because it was characterized as hounding by reporters. 19. Unfortunately, since the injunction statute, Florida Statute 784.048, is not being interpreted to narrowly pursue a compelling state interest, to wit, reducing physical violence, the statutes Florida Statute 790.233 and Florida Statute 784.0487, 4a, 7 designed to support the injunction statute, which 2 statutes clearly infringe in an individual's right to keep and bear arms, cannot be said to be constitutional, if applied without reference to violence. 20. In the instant case, a review of the civil injunction case involving the defendant, there is no allegation that the conduct that the plaintiff described, in any wise gave rise to a concern for her physical safety. The testimony of the plaintiff at the March 5, 2019, hearing was to the effect that he wouldn't leave her alone as she attempted to man her booth at the farmer's market. He kept coming back week after week, videotaping her, posting videos of him humiliating her on his YouTube site. The judge's conclusion was that the defendant kept returning and causing distress. Neither the plaintiff's testimony nor the judge's ruling makes 4. reference to physical violence or any concern for future violence. Therefore, as applied to the defendant in the instant case, these two statutes cannot pass constitutional muster. It is therefore ordered and adjudged that defendant's motion for judgment of acquittal or to dismiss must be and is hereby granted. Having concluded that the two statutes in question are being unconstitutionally applied to this defendant, there is not a need to consider the constitutionality of the statutes themselves. Whether or not the Florida state legislature has the authority to create a cause of action for injunctive relief based on the conduct described in the civil injunction petition is also not an issue being addressed by nor ruled upon by this court by this ruling. Done and ordered in chambers at Charlotte County Justice Center, Punta Gorda, Charlotte County, Florida, this 2 of April, 2020. Copies to Office of State Attorney Kevin C. Shirley, ESQ1PAQD. 5.
Hey Charlotte County, this is Charlotte County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.